Yes, be ready. 5 seconds. Start. The Allahabad High Court has observed that in an appeal against the order of acquittal, there is no embargo for reappreciating the evidence and taking a different view, but there must be strong circumstances to reverse the order of acquittal. Stop stanza. In the appeal against order of acquittal, the paramount consideration of the appellate court should be to avoid miscarriage of justice. Or must be strong circumstances to reverse the order of acquittal. The bench of Justice Vivek Kumar Birla and Justice Muhammad Aslam observed. Stop stanza. These observations were made while allowing government appeal against a judgment and order passed by Sessions Judge Bada in 1985, by which three accused respondents were acquitted from the charge of offence punishable under sections 302/34 IPC. Stop. One of the respondents died during the appeal (RJ). Stop stanza. Court's observations. Stop. The court noted that the witnesses in the case had consistently deposed about the overt acts of the accused, that all of them had opened fire on the deceased. Stop. Regarding the arguments of respondent/accused that the evidence of the witnesses could not be relied upon as they are interested/related witness. Stop. The court noted that the relationship of witnesses PW1, PW3 and PW4 with the deceased cannot be the reason for doubting their testimony. Stop stanza. In this regard, the court observed thus. Stop. While appreciating the evidence of witness, approach must be whether the evidence of witness read as a whole appears to have a ring of truth and consistent with the prosecution case, or to find out whether it is against the general tenor of the case. Stop. Their evidence cannot be doubted merely because they are related witness. Stop. All that is required is that their evidence is to be scrutinized with care and caution. Stop stanza. Further, the court opined that the evidence of PW1 Chandar Bhushan, PW3 and PW4 Srimati Asa Devi were consistent and credit worthy, and the same was corroborated by medical evidence. Stop stanza. The court also noted that in the case 5 gunshot injuries were found on the body of the deceased and 65 pellets were taken out from the body of the deceased, and 4 pellets were also found on the right buttocks of the blocks. Stop stanza. The court also observed that the pellets indicated that accused were armed with 12-bore gun, and that the deposition made by the doctor that the deceased might have died on the spot on account of that injury, or have survived for about 10-15 minutes, was consistent with the testimony of witnesses PW1, PW3, 37 and PW4. Stop stanza. Significantly, the court noted that the post-mortem report and injury report of blocks had corroborated the manner in which occurrence has taken place as stated by the prosecution witnesses. Stop stanza. The statements of the witnesses PW1 Chandar Bhushan, PW3 and PW4 Srimati Asa Devi get assurance from the post-mortem report and injury report of the blocks. The court stressed, as it found glaring mistake in appreciation of evidence in the impugned judgment of the trial court, which resulted into miscarriage of justice. Stop stanza. Therefore, nothing that the trial court had wrongly discarded the testimony of eyewitnesses PW1, PW3 and PW4 on flimsy ground by recording perverse finding, the court said that the judgment of acquittal was liable to be interfered. Stop stanza. It is fairly well settled that in an appeal against the order of acquittal, the appellate court would be slow to disturb the findings of the trial court, which had the opportunity of seeing and hearing the witnesses. Stop. In an appeal against the order of acquittal, there is no embargo for appreciating the evidence and to take a different view, but there must be strong circumstances to reverse the order of acquittal. Stop. In the appeal against order of acquittal, the paramount consideration of the appellate court should be to avoid miscarriage of justice, the court remarked as it allowed the state appeal against acquittal of the accused. Stop stanza. The remaining accused, respondent number 2 Ram Sarup son of Ram Kumar and accused respondent number 3 Dheeraj son of Ram Kumar, were held guilty of committing offences punishable under sections 302/34 IPC, were sentenced to life imprisonment. Stop stanza. Case title State of UP versus Lakshmi and others bracket start Government Appeal number 2995 of 1985 bracket close. Stop stanza.